Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And did you plead guilty because you actually did what they charged you with?
No, ma'am, I'm just ready to do my time.
Well, it doesn't work like that.
I don't have anything to say with it. I know I never touched him.
Okay, so then I'm going to delete this paperwork, and what we'll do, Ms. McMillan.
Can a defendant plead guilty while insisting they didn't commit the crime? That's exactly what happened in this unusual courtroom hearing. A woman charged with injury to an elderly individual told the judge she was ready to do my time, but then declared she never touched the alleged victim. What happened next completely changed the course of the case.
Good morning, ma'am. Are you Cadisha McMillan?
Yes, ma'am.
And this is cause number 26 DCCR 0647. And I'm going to take judicial notice of the court's file in Ms. McMillan's case. Ms. McMillan was evaluated for competency to stand trial by Dr. Capon. I received that report dated June 23rd of 2026. The finding in the report is that Ms. McMillan is currently competent to stand trial. Is there any other evidence with regard to competency?
No, Judge, not from the state.
Then at this time, based on that report, I am going to find Ms. McMillan competent to stand trial. Mr. Lewis, will she waive the formal reading of the indictment?
She does.
Ms. McMillan, you're charged with the third-degree felony offense of injury to an elderly individual from March 16th, 2026. And how do you plead to that charge?
I plead guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And did you plead guilty because you actually did what they charged you with?
No, ma'am, I'm just ready to do my time.
Well, it doesn't work like that. If you didn't do this, then you get a trial. So here's the thing, before you go any further, when you stood over in front of the clerk a minute ago, you raised your right hand and you said you promised to tell the truth, right?
Yes, ma'am.
So if you're guilty, you're guilty. If you're not guilty, then we'll get your case set for trial, but I'm not gonna allow you to plead guilty with something you didn't do.
Yes, ma'am.
Okay, so if you want to talk to Mr. Lewis for a minute again, that's fine. If you're going to take responsibility, then I'll ask the same questions again, but that's going to be up to you.
Yes, ma'am.
What do you want to do?
I mean, I don't have anything to say with it. I know I never touched him.
Okay, so then I'm going to delete this paperwork, and what we'll do, Ms. McMillan, is I'm going to set your case for trial.
Yes, ma'am.
When I set your case for trial, Mr. Lewis is appointed to represent you at this point. He handles a lot of cases for me here as a appointed attorney. With your permission, I can release him and I can appoint another attorney who could get ready for trial a little quicker. Is that okay with you?
Yes, ma'am.
All right, then, Mr. Lewis, you're released. Ms. McMillan, we will get you an attorney appointed today. They'll be out to see you very soon to begin preparation for trial.
Yes,
All right,
ma'am.
you go back with the bailiff.
Yes.
And Mr. Smith, if you'll make a notation, make sure, obviously, that's, I mean, we'll see what the other attorney does, but I don't intend to keep that deal. I'm sure you don't either.
No.
All right, Cadisha Scott. Morning, ma'am. Are you Cadisha Scott?
Yes, ma'am.
And this is 26 DCCR 0797. Ms. Scott is charged with the first-degree felony offense of aggravated robbery from July 3rd of 2025. And what is the announcement?
Judge, in this situation, we have the complaining witness who's evidently been trying to get in touch with the state
Okay.
in regards with this issue. And actually, I talked to the complainant myself a few times where they've called me saying they've called trying to get in touch with the office. I've given them their number up there so he can get that taken care of. That's the main weight that we
Okay.
have on our end.
Sure.
And Judge, I mean, in the meantime of that, of course, I would like to possibly either, I know we may not be able to take care of it this morning, but at least get a bond hearing set from Ms. Scott until we can get that worked out.
Let's do this. I mean, is there any reason you can't try to get that worked out this week to get in touch with them?
This is a case I inherited from Mr. Coleman.
Okay.
The number that Mr. Lewis has for him is the number that we have in the file. We did send him a letter. Tommy sent a different letter than we normally send, and it was returned. So I don't know about the address, but the phone number apparently is good. I didn't have a message that he had called, but I will reach out to him.
Okay. Let's do this. I'm going to reset it 2 weeks, and that'll give Mr. Smith time to kind of get caught up, make that phone call, get in touch with them. If by that time, between now and then, if you want to go ahead and file a motion for bond reduction, that way everybody's on notice and we can have that hearing on that date if something else doesn't get taken care of.
Good.
Okay. All right. See you back in 2 weeks. Joshua Smith. Yeah. The whole time for us.
Thank you, Judge.
Morning, sir. Are you Joshua Smith?
No.
And so, Mr. Smith, before you came out, Mr. Lewis explained that some of the hesitation you have, that there's an agreement that you guys have worked out that you're willing to accept, but you're a little concerned because Harris County does things differently, I think, than we do. I just want to let you know how we do things. And then if you want to enter that plea, you can. If you want to go to trial, you can do that, okay? What I do is if someone pleads to an agreed plea, I do take that plea today, and then I reset your case for sentencing. During that time period, I have the probation do a pre-sentence report, just so that I have more information when we come back. If for any reason at that time, there's something in that pre-sentence report that makes me say, you know what, I'm not going to follow this agreement. And what I do is allow you to withdraw your plea of guilty, and then we start all over. You go to trial or y'all work something else out. I'm never just going to give you something if I don't agree with what that is. That's not how we do things. So if that helps with that understanding, I'm gonna let you visit with Mr. Lewis again, and go over that, but it's definitely I don't do that. I never have, and I never would do that. I don't think that's actually the right way to do it. So you're pleading guilty based on an agreement. And so if you don't take that agreement, or if I don't take that agreement, we'll start all over. Okay, all right, y'all go back and visit. Again, you're Joshua Smith.
Yes.
And Mr. Lewis, will your client waive more reading of the indictment?
You do.
Mr. Smith, in cause number 25, DCCR 1439, you're charged with the first degree felony offense of fraudulent use or possession of identifying information in the amount of 50 or more from August 20th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Lewis? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenors number 1.
No objection.
It's admitted. Is there any evidence that Mr. Smith is not competent?
No, Judge.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so we can get that PSI done, and then we'll come back later for sentencing. Mr. Smith, what is your position with regard to bond based on that?
We're not opposed to a PSI bond on this, Judge. I believe there's a little bit of criminal history, but I think it'll be fine on this case.
So, Mr. Smith, what I'm going to do in your case is, based on the nature of your plea, is reduce your bond to $1,000. If you're able to make that bond, there's a couple of very important things about it, though. The first thing you do when you're released from custody, if you make that bond, is go to the probation department so you can get that pre-sentence report and started. You're going to get some information today, some paperwork, so that you'll know where to go. Also, if you bond and don't do that, if you don't show up, don't get that report done, you run the risk of me not accepting the plea agreement. If you're arrested for anything between now and when you come back, you obviously run the risk of me not accepting the plea agreement. And there's no, I was going to ask this a minute ago, there was no restitution or anything like that. All right, so you'll get some paperwork from probation this morning. If you make the bond, do everything you're supposed to. If for some reason you don't, they'll come out to the jail and do that pre-sentence report out there. Okay, see y'all back at sentencing.
Thank you.
No.
This hearing is a reminder that the criminal justice system isn't designed simply to process cases as quickly as possible. Even when a defendant says they're willing to accept punishment, judges have a responsibility to make sure a guilty plea is legally valid and supported by the defendant's own admissions. When McMillan told the court she was ready to serve time but insisted she never touched the alleged victim, the judge immediately stopped the proceedings. Rather than accepting a questionable plea, the court protected her legal rights. appointed new counsel, and moved the case toward trial, where the evidence can be fully examined. Whether this case ultimately ends with another plea agreement or proceeds all the way to a jury trial, the next hearing could dramatically change its outcome. Subscribe to follow this case and see whether the newly appointed defense attorney negotiates a different resolution or whether this unusual plea hearing leads to a full criminal trial where the evidence is finally presented in court.